full stop. Thereafter, the DPC met on 03/06/2023 and recommended for the upgradation of the petitioner from the post of Deputy Registrar in pay level -12 to level -13 as per the revised pay 7th CPC or PB-4 within brackets rupees 37,400 -67,000 close bracket plus GP rupees 87,000. That is from Deputy Registrar to Joint Registrar at NIT Mizoram with effect from 06/09/2016. That is the date of her eligibility for upgradation. After 5 years of service as Deputy Registrar, as per the what rules? Existing rules is what? What is the rules? As per
this is 2019. RR 2019.
As per the 2019 recruitment rules.
Yes.
Is it?
Yes.
Okay, we'll leave it at full stop. The recommendation of DPC was then placed before BOG held on 14/06/2014. Wherein her upgradation was approved, but with effect only from the date of the meeting, that is 14/06/2024, and not 06/09/2016. Good stuff. Aggrieved, the petitioner had approached this court by filing WPC 141/2024, and the said WPC was disposed of by order dated 20/01/2025 without entering into the merits, and directed the respondents to dispose of the representations made by the petitioner for consideration of her upgradation from 06/09/2016. Stop. The petitioners thereafter in its meeting
The respondent number 4.
The petitioner / respondent number 4, okay, in its meeting held on 21/03, is it?
21/02,
2025. Held that the upgradation of the petitioner and her redesignation as joint registrar within brackets personnel to the incumbent close bracket at NIT Mizoram should be effective with effect from 16/06/2024 within brackets the date of approval of the Board of Governors close bracket, and that it cannot be given retrospective effect from the date of completion of 5 years since the requirement of DPC and approval of the Board of Governors was not fulfilled. Aggrieved by the said decision made by the Board of Governors on 20/03/2025, the instant writ petition has been filed. Issue notice of motion to the respondents.
Lordship,
Ms.
I'll accept notice on behalf of my senior for
Baby
respondent number
so-and-so
1.
accepts notice on behalf of her senior, Ms. Zairam Sangpui, learned CGC, for respondents
Number
number
1.
1. Then any other notice be issued to the respondents number 2 to 4, is it?
Okay, continue.
2 to 4.
Lordship,
2 to 4.
we have served not a copy of the writ petition to the Standing Council, Mr. C.
To be issued formal notice anyways, 2 to 4 through registered post with AD within with 3 working days, returnable by 3 weeks. That you settle with the this thing why registered post is not required if the standing council has received, isn't it?
Yes, yes.
Requisite copies of the writ petition to be duly furnished to the learned counsel for respondent number 1. That's the matter after 3 weeks.
Okay.
Just make it issue notice to the respondents number 2 to 4, if not already done, through registered post. Okay. With the
Submission item 2.
My lord,
if not already served.
my lord,
Yes.
Mr. Monojit Biswas has today morning informed me that he couldn't appear today as he has important matter in the principal bench and asked me to seek adjournment. The leading counsel of the petition.
What is the stage? The
Admission
respondents, have you all filed your counter affidavits?
Yes, Your Lordship.
All filed?
My lord,
Yes.
Okay. Mention is made on behalf of Mr.
Monojit Biswas.
Is your name there in the cost list?
No, my lord. My
Okay,
name is
on behalf of Mr.
Monojit Biswas.
Monojit Biswas, learned counsel for the petitioner for adjournment of the matter, since he is not able to appear due to some personal difficulties. Full stop. Ms. London Louis, learned government advocate for this state respondents number 1
1 to
to
4, Your Lordship.
4 is present, along with Ms. Valentina Laldinpui,
5
Learned
to 7.
counsel for respondents number 5 to 7. The learned counsels for the respondents submit that they have already filed their counter affidavit. Stop. In view of the above,
My lord,
This the
kindly give
matter-
us the matter, fix the matter on 4th of August as requested
On-
by the petition.
of 4th 8/2025 as prayed for by the learned counsels. Yes.
Obliged.
Item 3.
My lord, this is a criminal petition.
Speak loudly on the mic. Which item?
Item 3.
On the mic loudly, okay, so that
Item
they
3.
will know. Yes, 3. It's a writ petition.
Yes, my lord. The affidavit in opposition filed by the respondents complete.
Yes. So have you filed your affidavit, counter affidavit?
Yes, Your Lordship. State has filed. Union of Media also filed.
Filed. Then anyone else to file?
Respondent 9 to 11 will not be filing.
Will not be filing.
Yes, ma'am.
So pleadings complete, or you're going to file your rejoinder affidavit?
I'll make all submission. I will not.
Not be?
Yes.
Okay, pleadings are complete, is it?
Yes.
Mr.
Simon Tong Asylum.
Samuel Asilo, learned counsel for the petitioner is present, along with Mrs. Linda L. Fumble, learned edition and AG for the state respondents, and Miss Baby so-and-so appearing on behalf of Miss Zarim Sangpui, learned CGC, for the Union of India. Full stop. The learned councils submit that they have filed their counter affidavit. Full stop. Mr.
Lordship David Lalompuya on behalf
David
of Alan
Lalompuya appearing on behalf of his senior Mr.
Hussain.
Arnold Monsiama, learned counsel for respondents, private respondents, is it?
For LADC.
Or for the LDC respondents number
9, 10, and 11.
9 to 11 submits that they will not be filing any counter affidavit. In view of the above, it is seen that pleadings are complete. Matter to be listed for admission hearing after 2 weeks.
Complaint.
Item 4.
Your Lordship, in this case, respondent number 1 to 3, 4, and 5 had already filed their counter. However, Your Lordship, affidavit filed by respondent number 1 to 3, there's a page number 1 and 2 are missing. I have not received.
Let's see.
Yes,
1 to 3.
in my copy.
No, so you,
Yes.
that shouldn't be difficult.
And Your Lordship, in their affidavit,
Huh.
they have stated in para 17, NPCC, National Project Construction Corporation is necessary party. So I may be allowed to
Okay, impleadment
implead.
application.
Yes.
Third was Dinari Tiazu, learned counsel for the petitioner, who submits that on perusal of the counter affidavit filed by the Union of India, she prayed that, no, who submits that after the perusal of the counter affidavit filed by the Union of India, she may be allowed to file an impleadment application in the instant case. Yes.
And then, my lord, I recently submit my power and I'm standing on behalf of the respondent number 6. Respondent number 6. And I pray your lordship to kindly grant me at least 3 weeks for filing my affidavit in opposition.
Okay, then Mr.
Procedural Thangmoya.
P.C. Thangmoya, learned counsel submits that your name is already there, that he has been recently appointed to represent respondent number 6 and prayed for time,
Yes, yes, my lord.
and prayed for time to file his counter affidavit. In view of the above submissions, this is the matter after 3
Your
weeks.
Lordship, I may be also allowed to reply the affidavit filed by the
Okay,
respondent.
list after 3 weeks. In the meantime, the learned counsel for the petition may also file the rejoinder affidavit to the counter affidavits filed by the respondents.
Much appreciated.
Item 5.
My lord, if I may please.
Yes, what is this matter about?
My lord, this is an application, it's a criminal petition for release
yes,
of.
yes, that vehicle, something.
Yes, my lord, Tata Punch,
Yes,
bearing registration.
yes. So you are saying that it belongs to you.
Yes, my lord. My lord, we had annexed, at annexure
Previous
number,
letters,
yes, annexure number 2 at page 9.
page 9.
That is the registration certificate issued by Government of Mizoram, which is in the name of
So
the,
it's in your name, Lalpek Twanga, is it?
Yes,
Are
my
you
lord.
Lalpek Twanga?
yes, my lord.
Then,
Then, my lord, annexure number 3 at page 10 is the finance, the loan statement, loan details.
so are you still in this thing? Are you still in jail? Have you served your term of sentence?
My lord,
Term is very less, a
the-
few months.
yes, the wife came last week. She was, this week she came and she was supposed to give the fines. but the learned trial judge is on leave.
Okay. What is the sentence?
5, my lord, it's at page 5 months.
5
At page
months.
22.
And pay a fine of rupees?
10,000.
10,000, okay. Yes,
To object this petition because the petitioner has pleaded guilty.
pardon?
The petitioner has pleaded guilty, and he has been convicted. And under section 60 of the NDPS Act, my lord,
Yes.
a vehicle is liable to be confiscated only if it can be proved that it was used without his knowledge.
A section?
Section 60. Clause 3, my lord, the last one.
Unless the owner proves that it is so used without the knowledge of
Connivance of the owner himself, his agent, if any, and the person in charge of the animal or conveyance, and that each of them had taken all reasonable precautions against such use. And in this case, my lord, the present petitioner is the owner of the vehicle, and he has been convicted of this crime.
What is his convicted under section?
B.
What is 21B?
My lord,
Wait,
it's
let's
at
see,
page
let's-
21.
21B?
Pick-
So it is where the conviction involves quantity lesser than the other thing. So he is convicted
My lord,
for
if,
involvement of quantity which is lesser than the commercial, this thing.
my lord, if I may take your lordship to page 21 of
Page-
the, yes, my lord. The
Wait,
order,
wait, have you completed
Yes, your lordship.
only on those grounds? Okay, yes.
yes, my lord, if I may take your lordships to page 21 of the petition.
Of the petition?
Yes, my lord, which is the order of the trial judge.
Yes.
Number 1, on the second line, Ms. Dalat Pektuang are convicted of the charge under 29(1) read with 21B of the Act on 8/5/2025 are produced. That, my lord, if the records may be called from the trial court, because in the evidence it is clearly proven that
What?
that the
See,
accused.
21B is this thing, lesser quantity,
Yes, my
not
lord.
commercial. 29(1), let's see. You don't have to call for records. 29(1). What to? This is for admittment. So vehicle, whether vehicle is involved or not is not mentioned. We'll allow, I'll pass the order later.
Yes, my lord.
Orders, item 6.
Deeply obliged.
My lord, as requested by the parties, the counsel for the state, Ms. Van Nasim is not here.
Wait. Status here.
If the matter
So
may be
don't-
fixed for, on Tuesday, your lordship.
Status here. Let them say. Isn't it? Because the PP can also appear on behalf of Ms. Vana Isyami.
My lord,
Unless you are going to pray for
since,
adjournment.
the additional PPs on legs, my lord, this matter can come up on Tuesday.
Okay. Heard Mr. H. Zodin Sanga. You see,
Jonathan L.
you-
Simon.
Oh, okay. See, you should be pressing for the matter, not praying for adjournment on their behalf, because the PP is here, she can pray on behalf of the additional
Why not?
PP,
Why not?
isn't it?
Why not?
I heard Mr. Jonathan so-and-so, learned counsel for the applicant / petitioner. Also heard Mrs. Linda L. Fumble, learned PP, who submits that since the matter is taken up by Ms. Savannah Isiami, learned additional PP, who is on legs in the other court. The matter may be, she prayed that the matter may be adjourned. In view of the above, this is the matter on,
As a fixed item, Your Lordship.
on what's the
Tuesday.
date?
Tuesday, Your Lordship.
29th.
Yes, my lord.
29th, 7/20/25. Yes.
Item 7.
So pass over, but no, even this matter, my lord, if it can be passed over for the time being.
See, this is the only item. Do we have any hearing matters to be heard today?
Last item. Pass over. Take on,
So in these matters where you find that the additional PP will not be, because these are bail matters, not so difficult. Yes, she's here. This is item number 7.
Lordship, in this petition, I'm a permanent resident of Borda Boldi, Part 1, Hailakandi, Assam. So I'm a driver under Tahir Ahmed. In the month of October to November, I got leave, and on dated 9/11/23, my master called me to join my service. So I came to my home, and when I reached Vairengte, Saira, my master Tahir Ahmed dropped me at Konpui. That vehicle was already there. And after that, I drove the vehicle to collect a fine shed from Assam. So on that day, 9/11/2023, at around 9 p.m., I got arrested at checkpost due to seizure of 1.437 kg of suspected heroin. And a case was registered on the next day, 10/11/23. And I was charged under section 21C and 25 of NDNPS Act. In this regard, my lord, I had no knowledge about the suspected heroin. It was clearly shows in my statement, which is in page number 30, annexure, page number 30, and 31 is English translation.
Charge sheet has been filed.
Charge sheet has been filed, yes, Lordship. Charge sheet has been filed on 7/3/2024. There is 6 witnesses. PW1, who is the seizing officer, was examined on 12 June 2024. And PW2 is examined on 2nd August 2024. Thereafter, no witness was examined till that. And
How many prosecution witnesses?
6, Lordship.
Out of 6,
Out of 6,
2 have been examined.
2 have been examined.
Okay.
And PW3 was dropped on 6/5/2025. Due
So 3 remaining.
3 remaining, Lordship. And Lordship, in this, as per based on the deposition of seizing officer, which was in page number 63, point number 4, if I may allowed, if I may read. It is a fact that I have not taken ground of belief at the moment I conduct checking the vehicles. It stated that, Lordship, when the checking was conducted, there is no ground of belief. There is no permission from the higher authority. That one is he's posted at Paishan check gate.
Then
So,
after that, after checking the vehicle, we saw the essay. Well, and after that, I wrote my ground of belief. Yes.
yes, Lordship. And in point number 10, he admits that he didn't obtain search warrant from the conducting searching. And Lordship, in page number 64, there is a violation of section 42 and 41. And
Where?
moreover, page number 64 in cross-examination, point number 5, it is affected. This is the position of civilian witnesses. It is affected. Search was completely finished when I reached the PO, and the search was conducted. It clearly proved that the search was conducted without the presence of civilian witnesses. And Lordship, seizing was based on the seize report, which was in page number 27, annexa. If I may allow, if I may read,
Page
27.
27.
Second para. This letter is dated 9/11/23. It is the night of I got arrested. On the night 9/11/23, 10 p.m., while conducting vehicle checking at Paishan police check gate, self-with party recover 112 shop case containing brown powder suspected to be heroin number 4, 1.437 kg. Arrest 43,11,000 in prevailing market rate for one vehicle tipper truck bearing number such and such, driven by Jawul Islam Barbuya, son of such and such, resident of Border Boldi, Part 1, Hailakandi, Assam, proceeding toward Hailakandi, Assam from Konpui, Kolosip district. Here, recover items were seized in the presence of reliable witness. The conveyance vehicle, which is document ignition key, were seized in the presence of reliable witness. Lordship, in here, the most relevant part is that the seized item were sent to court for the interest of the case. The accused Islam Barbuya, resident of such and such, was also arrested after informing ground of his arrest, and after intimation was given to his relative. The seized item 112 soap case was containing brown powder suspected to be heroin, along with the accused were sent to court from the interest of the case. Lordship, it's indicated this letter was made after everything was complete, but the date is 9/11/23. Here it clearly mentioned that the essay were sent to court, the accused was sent to court. So
what's wrong with this?
in this regard, the accused was sent to court on 10/11/23.
The next date?
On the next date, yes, Lordship. This was in 10.
Within 24 hours? Is that what you're trying to say?
I'm trying to say is that this one is a big date, Lordship.
No, this letter was the report of Caesar,
Yes, Lordship.
reference letter 10th so and so. How is it backdated?
The letter dated is 9.
Okay, 9/11.
9/11, yes. But the accused was sent to court on 10, along with SA. Lordship, in this regard, the accused and the seized article were sent to Bairengte police station only on 10/11/23 at 8:15 a.m. There is no weighing.
Where is it shown? 8:15.
It was shown in Uh, uh, Page number 16, charge sheet.
Okay, this ASI is the seizing officer, is
Yes,
it?
yes, Lordship.
Has he been examined?
Yes, Lordship.
So was this questioned? What did he say regarding this in
Uh,
the cross-examination?
in cross-examination,
What is his explanation?
he says that
Witness number
from page number 62.
62. Okay, yes.
In page number 63, point number 12, it is effect that on 10/11/23, I had produced the essay accusation vehicle to Vairengte PS. At the whole night, he
So,
kept,
so did you question about this exhibit number? Was a question asked about the dates in exhibit number 7?
no, Lordship.
Why? That should have been asked, then we would have been clear.
Yes. Sir, Lordship, in page number 15, I mean point number 15,
15, yes.
point number 15, it is effected after we recover SA information, I inform the OC Vairengte. Here also it's proof that,
It is a fact, a suggestion, so he informed.
yeah,
Now you are trying to say, but this is, so regarding exhibit
yes,
7, that should have been pointed in the cross. Now I want to see about exhibit 7. Now you are telling me that regarding exhibit 7, there is something wrong with the dates.
yes, Lordship.
Then when the officer was examined, that should have been brought out. Then we'll see his explanation for that, isn't it?
Yes, Lordship.
Nothing was asked during cross. So at this stage of application for bail, all that, it's, anyways, go ahead.
Yes. Lordship, here in my point is that I had no knowledge about the SA. And there is a violation of section 41 and 42. There is no search warrant. I mean, there is no warrant from before I conduct search, and there is no ground of belief before search, and no civilian witness were present at the time of conduct searching. It was proved by the deposition of PW2. And like I would like to say that, Lordship, the sample were sent to FSL only on after 12 days on the date of sample was drawn. It was proved by page number 38. Here is FSL report. It indicated your memo number such and such dated number 21/11/23, advising the examination of 8 per register we received in the office on 23, which is sent on 21, and it was received by 23, Lordship. It is also a violation of the rules.
Which rules?
The rules 11 of 2022.
What do they say, rules
It
11?
says that
Yeah, give me the NDNPS Act. Is it NDNPS?
yes, Lordship. It,
Rule number
11.
11, withholding or cancellation of license.
No, Lordship, this one,
What rules are you reading? NDNPS rules.
yes, 22. If I'm allowed, I will submit this one.
From where are you getting that? From a
This
book
one is
or
from internet.
internet?
Yes.
See, we have you're reading the NDNPS rules, 1985, is it?
Yes, yes.
Then here the rules is available We have to look at the Bare Act.
Yeah. In the barrack, I think it was not mentioned.
Then, from the internet.
Yes.
I don't know. That I will not depend on. Let's see who has authored this. Show me. Find out from where did you get the rules? Because if you're saying Rule 11, I'm looking at maybe there is such a rule.
Number 30, Lordship.
13.
Yes.
Okay. Not 11, 13.
Yes,
Procedure or read the rules. Rule number 30. Read from the Act, not this something. Okay, let me see. We have the Bare Act with us, so we have to depend on the Bare Act,
Yes,
isn't it?
Yes.
This is seizure and storage, sampling and disposal rules. Say those rules. Okay. So now we have to look at the. We'll have to look at the proper rules in the book, not any. Get those rules. Seizure, storage, sampling, and disposal of rules, 2022. It should be here. See if it's there. Court master. See, search. These are, okay, it's in page 200, the last page. It's here.
Yes, Lordship.
13.
Yes, Lordship.
Simply saying rules. Yes, you can take this back.
Yeah. If I may allow to read para number 1. The sample after being certified by the magistrate shall be sent directly to any one of the jurisdictional laboratories of the Central Revenue Control Laboratory, Central Forensic Science Laboratory, or State Forensic Science Laboratory, as the case may be, for chemical analysis without any delay. Lordship, here, I would like to mention that there is 11 days delay for sending the sample. And also here, Lordship, I would like to mention that in page number 38.
Who is the case? It's for the case. I ought to just explain that, isn't it?
Yes, Lord.
Anyways, so 38.
Page number 38, description of exhibition. It also violates that rule number 11 of the said rule. Quantity to be drawn for sample. If I may allow, let me read. Excess in case of opium, ganja, and charas, where a quantity of not less than 24 gram shall be drawn for each sample. In all other cases, not less than 5 grams shall be drawn for each sample, and the same quantity shall be taken for duplicate sample. Proceed, here 8 sample was drawn. Only 2 samples are above 5.5 milligram. The other 6 samples are less than 5.
Minimal less, 4 point something, just a few points.
Yes.
So we'll have to see what is the weighing machine. Yes.
There is also violation, Lordship. I would like to mention that. And like I said, there is a violation of section 41 and 42. And no civilian witness was present. No ground of belief was recorded before conducting search. No warrant was there. So I humbly pray this honorable court to allow me to bail in the condition the court may decide, Lordship.
Yes. The 42 is when you can, this thing search without warrant, but they're
Yes.
saying there's no warrant.
Yes, Lordship.
Without warrant, they can do it in 42,
Yes, Lordship, without warrant, they,
without warrant.
but there must be ground of belief before searching that.
After receiving information, isn't it?
Yes, yes, Lordship.
So when did you receive the information? It was random checking. Anyways, let's hear the
yes,
additional PP.
Yes, Your Lordship, may it please Your Lordship. First of all, my lord, what I would like to mention is that the seize was conducted in the check post, and that is on 9/11/2023. And after recovering
Public place. What's the vehicle?
truck, commercial truck, who is carrying sand. And Your Lordship, the seized contraband article was seized from the back seat of the driver back seat. So it was seized inside the truck, and there is a presumption as per section 29 that he has a conscious possession, so which has to be proved during trial. And Your Lordship, another thing is that when they seized the contraband in Python check gate, it was detained, and later on it was produced before the Vairengte police station. So their formal arrest was done there. At the time of detaining, that is on 9/11/2023, formal arrest was not done, because that is the check post. And after bringing the accused to the police station, thereafter formal arrest and weighing of the seized contraband was done there. And Your Lordship, another thing is that out of 6 witnesses, 2 witnesses were examined, and 1 witness is dropped, so only 3 witnesses is
Which
remaining.
is the witness that has been dropped?
Independent witness.
The?
Independent witness. Private witness. And Your Lordship, what I would like to mention here is that minor non-compliance of procedure does not entitle the accused to be released on bail. And in that regard, my lord, I would like to rely on one citation.
No, you have a copy?
Yes.
Good. What is the citation? Hmm. 2024,
Yes, Your Lordship.
SCC online, SC 3848. Mr. Say those citations, because maybe the council would also have a look, isn't it?
Paragraph 39, Your Lordship.
Para 39.
If I may read out.
This is, which case is it? Name of the case, parties?
Kashif,
Narcotics Control Bureau versus Kashif. Para?
para 39.
See, we're doing your homework for you, simply giving without telling us what it is. 39. What does it say?
The upshot of the above discussion may be summarized as under number 1. The provision of NDPS Act are required to be interpreted keeping in mind the scheme, object, and purpose of the Act, as also the impact on the society as a whole. It has to be interpreted literally and not liberally, which may ultimately frustrate the object, purpose, and preamble of the Act. Number 2, while considering the application for bail, the court must bear in mind the provision of Section 37 on the NDPS Act, which are mandatory in nature. Recording of findings as mandate in Section 37 is sine qua non is known for granting bail to the accused involved in the offenses under the NDPS Act. Number 3, the purpose of insertion of Section 52A laying down the procedure for disposal of seized narcotic, drug, and psychotropic substances was to ensure the early disposal of the seized contraband, drugs, and substances. It was inserted in 1989 as one of the measures to implement and to give effect to the International Convention on the narcotic, drug, and psychotropic substances.
So
Number
this
4.
is regarding section, what? 52A, isn't it?
52A, as
52A is not
well as
52A.
my lord, here in subclause 5.
5,
Any procedural irregularity or
illegality found to have been committed in conducting the search and seizure during the course of investigation or thereafter would by itself not make the entire evidence collected during the course of investigation inadmissible. The court would have to consider all the circumstances and find out whether any serious prejudice have been caused to the accused.
Okay. Yes. Anything?
Yeah, Lordship, here I would like to mention is that the seizing officer got information before checking was conducted. Yeah, it was proof on page number 16, it's on charge sheet. Page number 16. Gist of the FIR on dated 10/11/25 Balalthara interest Paisen police check gets submit his inquiry report to officer in charge Varingte police station that affected on the night of 9/11/23 at 10 p.m. in pursuance of information received from the source. He with party conduct vehicle checking. So it clearly says that he
So
already
you're
got,
saying that information to next superior officer was done late, deleted late, is it?
yes, also, and he also received information. However, after receiving information, he didn't write down his ground of belief.
Okay.
That's all my point. So,
I'll pass the order later. I'll consider your submissions. Heard Mr.
K. Thang Rem Sang.
K. Klang Remsang.
Yes,
Is it learned counsel for the petitioner? Also heard Ms. Vani Siame, learned additional PP for the state respondents. Yes. It's disposed, I'll pass later.
oh, like my.
Part 2, item 10.
It's fixed for hearing today. Yes, who's the, for the respondents? For the respondents is Dalsan Diana. Anyway, none appeared for the parties. List the matter in the next week. Yes. Yes, oh yes, Mr. Johnny is here. We have called out the item, but who is the counsel for the respondent? Where is the counsel for the respondent? Okay, Mr. Johnny L. Tautsong, learned counsel for the appellant is present. However, none appeared for the respondents.
Lordship, this case is also one of the identified case for
Okay, for the respondent who submits that this matter has been identified for mediation in view of the above, the registry to send the matter for mediation. Yes.
yes.
So same, this thing, order in item number 4, 5, and 6, I think, of the part 2. Part 2 list also, no? For mediation, same order.
There's a one. Item number 14 is also one of the identified case. I don't know whether the insurance company is willing to refer or not. Item number 14 of part 2.
Part 2 list. Anyways, Mr. Johnny L. Tochong, learned counsel for the respondent number 1 to 4 is present and submits that this case has been identified for mediation, since it appeared that there's possibility of the parties coming to an amicable settlement. None appeared for the appellants. However, considering that this is a MAC appeal, matter may be sent for mediation registry to do the needful.
Yes.
Let's do it. If they don't come, it can always come back to the court.
Yes, Lordship.
Isn't it?
Item 11.
11, none appeared? Oh, yes.
Yeah.
Who is for the counsel for the opposite party?
I'm,
Oh,
Lordship,
okay.
yes.
Okay, can we hear the matter?
Yes.
Yes, we are ready, Lordship.
RFA.
Yes, RFA, but my lord, this is just a simple matter.
Okay.
It's a rejection of the airship application. So we come directly by challenging the rejection order. Yes. If I may state the history of the case. Yeah. There was the one Srimati Lalchwailawi who during her lifetime had a landed property covered by LSC number AZL2720 of 1985 located at Edenthar, Aizawl, Mizoram. So the said Lalchwailawi unfortunately died on 2016 and left her 3 daughters with her husband, namely Sri Kap Thanga. But the said her husband, the said Kap Thanga, died on 05/05/2020. So after the death of her mother, Srimati Lalchwailawi, the appellant herein applied for issuance of airship certificate and obtained airship certificate number 1069 of 2017 in respect of her late mother, LSC. Being aggrieved with the said issuance of airship certificate, the younger sister, namely Lalrem Sangi, had preferred unappealed, and the said RFA was disposed of for de novo trial, as sent back. So, as per the de novo trial order, we approached the civil judge tree, and the said civil judge tree opined that the value of the subject matter is above the jurisdiction of the civil judge.
Okay, civil judge jurisdiction is up to 10 lakhs, is it?
Yes, 10 lakhs.
10 lakhs, huh?
Yes.
Huh.
At that time, it was around, if I'm
Five.
not mistaken,
Five.
5. Yes.
Huh.
So the said airship certificate was returned under Order 7, Rule 10 for approaching the proper forum. Then the appellant herein had filed again airship certificate number 497 of 2021 before the senior civil judge tree, Aizawl, thereby putting the respondent herein as the opposite party. So after pleadings were completed, the final preliminary hearing was conducted without framing any preliminary issue. Yes. So if I may take your lordship to just after the index of the index, that is the order, and the relevant portion is at page 2, that Roman number 2. Your lordship has it?
Is it 26/6, 2023, the order?
Yes, my lord.
Oh, it's page 18.
Yes, page, the next page, under paragraph 5,
Okay, Roman number 2,
or paragraph 5.
para 5, yes.
Yes, if I may read.
Yes.
However, instead of, that is the mistake committed by the learned trial court, that the learned trial court did not mention about the return of the plane by the earlier civil judge. However, instead of approaching the trial court where the case had been remanded back by the Honorable Appellate Court, the petitioner herein has approached this court for issuance of airship certificate by making one Sri Lalrem Ruata, son of Jacob late, resident of Eden Tarwang Aizawl, as an opposite party. And at number 6, para number 6, in the light of the above discussion, the parties may approach a competent civil court and file an appropriate suit by making payment of requisite court fee and so on. It is therefore held that the present petition is not maintainable in its present form and style and thus rejected. So, if I may take your lordship to
But let's see a plaint. When you approach the
Yes.
senior civil judge, you must have filed your plaint
yes, yes.
mentioning the value of the property. Where's
Yes,
that?
It is at page 39, that is the plain. 39, Annexure 6. And the relevant portion is at page 44. 44, that is at para 12. If I may read, my lord. That this honorable court has both territorial and pecuniary jurisdiction to entertain this application since the petitioner is residing at College Bank, Aizon, Mizoram, and the value of the subject matter is more than 10 lakhs. So we have clearly mentioned that this court has jurisdiction, both territorial and pecuniary. So if I may take a lordship back to page 39.
Yes.
Yes. See, at the time of hearing, what the trial court has opined is that filing a declaratory suit, that is what it means. So, this airship certificate application is filed under Section 33 of the Mizo Marriage, Divorce, and Inheritance of Property Act 2014. So, if I may read the relevant portion, my lord, the Mizo Marriage, Divorce, and
Yes.
Inheritance of Property Act.
Yes,
So,
copy please.
Section 30, my lord,
Wait. Section?
33, section clause 3. Yes.
Yes.
Yes, it says that it is the jurisdiction of the court to to grant airship certificate in respect of any property as per Schedule 4. If we go into the Schedule 4, that is as in what manner the court has to give the airship certificate.
But when you approach the civil judge, you approach the civil judge, isn't it? Not the senior civil judge?
Yes, then the learned civil judge returned our claim.
Where's the, any order?
Yes,
Where's
it
the
is
order?
at page 37. After the learned
What is the finding? 37. What does it
37.
say?
Yes, the relevant portion is at page 38. Yes, last para. Resultantly, the airship certificate application number 1609-2017 is hereby returned as expressly provided under Order 7, Rule 10 of the Court of Civil Procedure.
Let's see what does Order 7 Rule 10 say. CPC.
If I may read Order 7, Rule 10.
Order 7 Rule 10. Yes.
That is return of plane, subject to the provision of Rule 10A, the plaintiff shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. So the former application, after the learned first appellate court sending back for the novo trial, the civil judge, the learned civil judge opined that it is above the pecuniary jurisdiction of the civil judge, and it returned the plain. So
Okay.
after return of plain, we have filed this heirship certificate application. So Schedule 4 has clearly mentioned that heirship certificate, and it has Schedule 4 of the Mizou marriage. Yes.
Yes, what does it say?
It has clearly mentioned that heirship certificate application number so and so of, that is how heirship certificate should be given. So filing a suit is not appropriate. It should be a petition, an application.
An application.
Yes. So we filed this application instead of filing a suit. So that is, in our opinion, the error committed by the learned trial court. So, well, there is nothing wrong in our plain, in our application. So there is no ground to reject the plain.
Okay.
So that is the only question we come before this honorable court, your lordship. So if I may, this court may send back the case and with the direction of proceeding as per
Okay.
law.
Yes. Oh,
Lordship, since it is necessary to adjudicate who will inherit the landed property, Lordship, and I do not have any objection if the matter is remanded back to the learned senior civil judge, provided that, Lordship, I may be given a chance to file a counterclaim.
now, both the parties should be given the chance.
Yes,
Okay.
yes, yes.
I'll pass the order accordingly.
No. They had already filed a counterclaim before the learned trial court. Pleadings were completed.
Lordship, I may be given a chance if
So we'll remand them back.
Trial
Both the
did not-
parties, are up to appear before. When
Yes,
do you want
yes.
to appear?
Okay.
Oh, on, give a date.
Okay.
What? Okay, give me a date. When will both of you be able to appear before the court on? I'll pass the order later.
No problem.
20 of August.
20?
August.
20.
Zero.
Okay, so I'll pass the order that allow both the parties to appear before the court on 20th August for further necessary actions. Okay? Then let the trial court decide. Yes.
Lordship, yes.
Right.